Snendlanta, very good afternoon. Great to have you on. So you believe that the High Court made certain errors in that outcome that kept the restrictions on tobacco in place. What are those errors?
Look, thank you for having me on your show, Tembegile. There's a number of errors. I mean, the first one, which we raised in our court papers, is the issue of costs. Now, one who would have had regard to the matter which was in court on the 10th of June 2020 would have noted that the state, in closing their arguments, did not seek a cost order against us as the applicants due to the fact that this was a matter of national interest. Yet the court seemed to find it fit to award a cost order against us, a cost order which was quite hefty in that it was a cost order which included the cost of 30 counsel. We further deal with the fact that the regulations, in as far as Section 27 of the Disaster Management Act, were rather ultra various of Section 27 of the Disaster Management Act, which regulations promulgated the sale of, or rather banned the sale of cigarettes and tobacco products. We further deal with the fact that the continued ban on the sale of cigarettes and tobacco products does not accord with the international standard, in that currently South Africa is the only country globally which has banned the sale of cigarettes. We further argue the fact that the test for rationality, in as far as the court applied, is too narrow and does not leave much of a test for government to meet, in as far as any party that seeks to challenge this ban. And there are many other aspects which we deal with our papers, because we are quite confident that another court will arrive at a different conclusion in as far as arguments which we raised.
And one of the other arguments that you took quite a beating on, if we can put it that way, was around cigarettes, saying that they should be considered essential because they are addictive. The court saying that just because a substance is indeed addictive does not render it essential. Will you centre that argument again in this appeal?
Look, that argument was never a centre of our application. For some reason, the media enjoys attracting a lot of attention around that particular argument, but it was an argument which was merely a couple of lines in as far as our application is concerned. I mean, our main arguments center around the rationality of the ban and the fact that the ban is ultra various of the Act, and that the Act does not empower the minister to enact such a ban in terms of the Disaster Management Act. And I mean, if you look at the test for rationality, which was employed by other courts, we are not in agreement with this. And further, the interpretation of the word necessary, in as far as it relates to the Disaster Management Act, case law is quite clear in that it states that acts of such a nature as the ban on the sale of cigarettes must be strictly necessary. Yet the court deviated from this test in handing down this particular judgment.
Just on the job losses, because that's come up a lot between March and where we are now, what is the latest update on the number of jobs that have been lost and companies in the tobacco industry that may possibly have to shut down?
Look, I mean, we've already seen it in as far as job losses along the tobacco industry value chain. We've seen a tobacconist, which I think was the oldest tobacconist in the country, shutting its doors because it cannot meet its overheads. That would have come with a lot of job losses in as far as the people that were employed by that particular operation. You would anticipate that there are many such tobacconists which would have had to shut down shop. You look at the farmers who have been complaining. A lot of them are saying they have not been able to trade. And we, of course, know that there are a lot of overheads associated with farming. Now, a lot of those farmers will now be left without a livelihood. We look at the informal traders, for instance, who many have complained that in as much as they have been allowed to trade, when the restrictions in as far as spaza shop owners and hawkers were lifted, they are not able to sell one of their core goods, which attracts a large portion of the revenue they generate, being cigarettes. And as a result, a lot of them are not able to make ends meet. We will soon see a number of cigarette manufacturers themselves shutting down as a result of the exponential growth of the illicit trade, in that once this ban is ultimately lifted, the legitimate cigarette manufacturers will not be able to compete with those who are selling illicit goods, in that those particular criminal syndicates do not pay the relevant taxes and can sell cigarettes for a cost of next to nothing and still make a substantial profit on those illicit goods.
And just on those 2 points then, again, on just in terms of the job losses and the issue of the flourishing of the illicit cigarette market, do you not have specific numbers that you'll be adding to your court submission?
Look, it's very difficult in as far as the tobacco industry to establish the number of people that it employs. We have put forward an argument in as far as our association is concerned and the number of job losses and the losses of profit in as far as our members are concerned. It is an argument that has been raised. And obviously, we have relied on some statistics in as far as the job losses. The illicit trade is quite a glaring one in that, I mean, there have been a number of studies during the lockdown period which have pointed out the extent of the illicit trade. I mean, the one that springs to mind is the one by the University of Cape Town, which stated that as much as 90% of smokers are still smoking, and we're seeing revenue losses to the tune of billions, in that these criminal syndicates are being enriched and the fiscus is losing out. And further, the legitimate manufacturers and players in the tobacco industry are not able to generate much of an income, and as a result, there will be job losses as a result of that. So we do raise those particular aspects, and it's one of the many aspects which we feel the court, in making the ruling, which was handed down on the 26th of June 2020, did not add sufficient weight to those particular arguments.
I want to ask you a final question, Snendlandla, because we have to wrap up our conversation shortly. The British-American tobacco case over the issue of tobacco is due in court in early August. Would it not be prudent for you, financially and otherwise, to wait for the outcome of that case before you proceed?
Look, there are obviously time periods associated with filing applications for leave to appeal. So we had to ensure that we fell in line with those. We are just as anxious as most people to hear the outcome of that matter, as we feel that it will have some sort of impact on our matter. But it would not have been practical for us to wait for that particular matter to be heard. As you know, one of the factors in our application is the issue of urgency. So in as much as it may have made sense to a number of people, as the current situation dictates, we were not in a position to wait, and we had to quite quickly make a decision on whether to appeal or not.
Snendlandla Mnguni, chairperson of the Fair Trade Independent Tobacco Association, good to have you on ENCA.